Very good morning, students. I'm Dr. T. Anita Kumari, Associate Professor of School of Management Studies, Wales Institute of Science, Technology and Advanced Studies, Chennai. In today's class, we are going to discuss about special contract. Under this special contract, we are going to discuss the following topic. Contract of Indemnity, Section 144 and 125. Contract of Guarantee, 1.6 to 147. Contract of Bailment, Section 148 to 181. And Contract of Pledge. So before moving to the topic, let us see the objectives of this special contract. To say the meaning of contract of special contract, to know the various types of special contract, to identify the essential elements of special contract, to understand the rights, duties of the special contract holder, to acquire the knowledge of the bailment, pledge, and indemnity. Bailment. So what is called bailment? Bailment is derived from the French word. It means bailment is to deliver. So, but in law, it refers to the contract which results from the delivery of goods. In contract of bailment, only the portion is passed, not the ownership. So, students, what is called bailment? When one person handovering the portion of the goods to another person for the purpose of adding the value to the goods is called as a bailment. The person who is handovering the goods to another person is called as a bailer, whereas the person who is receiving the portion of the goods is called as a bailee. So according to the English author David A.G. Sari, bailment is the delivery of goods by one person called bailer to another called the bailee on the condition that the same goods shall be re-delivered by the bailee to or on the direction by the bailer. For example, if A give his car to B, his neighbor, for 10 days, but at the same time he keeps the one key of his with himself, and during this period of 10 days he used to take the car. Now, this will not be case of a bailment as A is keeping control over the property bail. Students, under the Bailment Act, the particular bailer, he has to hand over the portion of the goods wholly. In case if he is handling the goods, or if he is partially having the, some custody of the goods, in the sense, it will not consider as a bailment. So these are the essentials of contract of bailment: contract, delivery of goods, change of position, purpose of delivery, number of parties, rights of ownership, change of form, goods in possession of bailee, re-delivery of goods, and rights of reward. What is called contract? So an agreement enforceable by law is called a contract. The first condition in the bailment is there must be a contract between two parties. Who are the two parties under the bailment? Bailer and bailee. So delivery of a goods. This contract is sale for the delivery of some movable goods from one person. That means from bailer to the bailee. Okay. So change of position. So here the portion of the goods is transferred to the bailee for certain period. Okay. So here the ownership of the goods is transferred from one person to another person. That is called change of position. Then purpose of delivery. For what purpose the bailer is handing the goods to the bailee? For adding the value or some other purpose. So always the change of position under the bailment carries some purpose. Number of parties. There are two parties under the bailment. Who are they? Bailer and bailee. Right of ownership. As I told you that under the bailment, only the portion of the goods is transferred, not the ownership, right? So here the ownership is with the owner. That means who is the owner? The bailer. Change of form. See, initially I'm I'm handovering the portion of the goods to the bailee for the purpose of adding some value to the goods. Here, at the time when I'm handovering goods to the particular bailee, the form of goods will be different, whereas the bailee will be re-delivering the goods in a finished state. That is called change of form. Goods in possession of bailee. So the delivery of the goods is not essential if the goods are already in the possession of the person who entered into the contract of bailee. Okay, for example, I went to one shop, textile shop or boutique shop. There, the boutique shop itself, some tailors are there. So I bought some goods. I bought some saris, but I hand over the sari to the same shop person to do for further stitching of alteration or blouse or whatever it is. In this situation, goods in a position of bailee only, because the particular textile itself, they are having the bailee, I mean the tailor. So they will be adding the value to the goods. So in day-to-day transaction, every day we are sometime entering in a contract with someone else. So for example, just we used to hand over our unstitched cloths draw cloth to the tailor for stitching purpose. We'll be giving our requisition that you have to stitch like this. We'll be giving a measurement. We'll be choosing the design, and we'll be asking the particular tailor to do stitching based on a requirement. These are all is called as a bailment. Okay, redelivery of goods. Under such contract, the goods is redelivered to the bailor according to his the instruction and direction. Then rights of reward. So once the bailee has completed his task, then it is a duty of the bailor to provide a reasonable reward, which is promised at the time of a bailment. There are basically three types of bailment: sole benefit of the bailor, sole benefit of the bailee, mutual bailment. So sole benefit of bailor in the sense, when the portion of the goods is given to the bailee only will utilize, enjoy the benefit of the goods. For example, I'm giving my unstitched cloth to the tailor. Even though the tailor has completed his task, he could not able to use it, right? He will return back the goods to me. Then I will start to utilize it. So who enjoy the benefit of the particular goods is a bailor here. That is called sole benefit of the bailor. Sole benefit of the bailee. One of my friend is asking car for 2 days. So I'm handovering my car to my friend. So who is enjoying the benefit of the car? My bailee, the person who's receiving the goods, right? So students, we have to very clear. Under the types of bailment, the benefit is enjoyed by whom? Based on that only it is categorized. Okay. Mutual bailment. When the two person, the bailor as well as the bailee, enjoy the benefit of the goods, that is called mutual bailment. Kinds of bailment. Apart from the three category, there are certain kinds of bailment. First one is bailment for safe custody. That means when one person handovering goods to another person, bailee, for keeping it for some period for safe custody purpose. That is called as a bailment for safe custody. A deliver his camera to B and to keep it in a safety custody for 6 months. This will be the bailment for safe custody. I can give you some other example also. I need to go some out of station. So for that purpose, I'm handovering my pet, maybe the puppy. I'm giving my pet to one of my neighbor. I requested him to take care of a puppy for next 1 month. So this is called bailment for safe custody. Bailment for use. If the bailor deliver the goods to the bailee to use it, the bailment will be bailment for use. Example, A deliver his bicycle to B to use it for 2 days. This will be example of bailment for use. Even you can give an example. You are handovering your books to one of your friend for a study purpose during the examination. Okay, here you are handovering goods to your bailee for utilization purpose. That is called bailment for use. Bailment for reward. So bailment for reward in the sense where the bailment is for the use or for the safe custody, and the bailor and the bailee use the services, then it will be a case of a bailment. For example, A deliver his bicycle to B to use it for 2 days. For that purpose, he is charging ₹50. In this case, the money is transferring, right? So whenever one person is handovering goods to another person, that means when the bailor is handovering the portion of the goods to the bailee and collecting some reward or some money, that is called bailment for reward. Next one, gratuitous bailment, where the bailment is for safe custody or for use and bailee does not charge anything. The bailment is bailment for gratuitous. Example, A delivers his bicycle to his friend B to use it for 2 days without any reward. It will be the case of gratuitous bailment. So here in this gratuitous bailment, the bailor will be handovering the goods to the bailee for the purpose of some personal use. For that, you are not charging any money. So students, be clear. If you are going to collect any money or reward from the bailee for the purpose of utilization of your portion of the goods, that is called bailment for reward. Whereas if you are not going to collect any money just for personal use or due to relationship, if you are handovering your goods to the bailee, that is called gratuitous bailment. Bailment for lost goods. So what is called payment for lost goods? Sometimes the person who find the goods which is lost, for that purpose he took a goods and he handed over to the bailor, in the sense that is called bailment for lost goods. A found the lost horse B and redelivered to B. It will be the bailment for lost goods. Do you understand? For example, sometimes we used to see in the newspaper, right? I lost this goods, I lost my property. If somebody bring it, I will reward it. That is called bailment for lost goods. Then bailment for pledge. When any movable goods are given as a security for debt or creditor by the debtor, it will be bailment for pledge until the repayment. Okay, example, A gets a loan B and hands over its B security until repayment of loan. Usually, if you are handovering your goods to somebody else for the purpose of money, that will come under pledge. We will see in the next topic. Bailment and pledge. Bailment and pledge is somewhat similar. Okay, so pledge in the sense where you are handovering your goods, your portion of the goods for the purpose of getting money. That is called pledge. So, for example, we might be knowing very well whenever we are in some financial problem, we used to mortgage our gold, right? We used to mortgage our gold, land, or any kind of important document, valuable things. Okay, important, important items or whatever it is, we will mortgage, right? That is called as a pledge. Whereas bailment is different. Bailment in the sense you are handovering your goods to someone else to add up the value for that. Then they will be redelivering the goods to you. Here, the portion of the goods only transfer, the ownership is not transferred. Okay. So here, bailer is the person who gives the product, bailee is the person who takes the portion of the goods. The transaction between the bailer and bailee is called as a bailment. Examples are hiring a bicycle, giving a cloth to the tailor, and delivering watch for repair. So two parties in a bailment, bailer who gives a product and bailee who takes a product. So these things we have then another basic two kinds of bailment. Gratuitous, non-gratuitous. Already I told you, gratuitous in the sense when you are handovering your portion of the goods to one of your friends, for that you are not collecting any money. If you are giving any product to the bailee for the utilization purpose, for that if you are not going to reward anything or if you're not going to charge anything, that is called gratuitous. Whereas non-gratuitous in the sense it is like some commercial purpose. When you are handovering your goods or handovering your product to somebody else, and after you for the purpose of utilization or for the purpose of service, you are charging something, that is called non-gratuitous. For example, I have some hiring cycle shop. So in this case, for every hour, I'm charging 100 rupees for hiring a cycle license. That is called non-gratuitous payment. The person who is taking a cycle, only the portion of the goods is transferred for temporary period. Then they will be redelivering the goods to the particular owner. So difference between the sales and bailment. Under the sale of contract, the ownership will be transferred. So when the buyer buys some product, once he give a money, immediately the ownership transfer under the sale of goods at 1930. Whereas under the bailment, here ownership is not transferred. Instead of that, only the portion of the goods is transferred from one person to another person. So duties of the bailee, who is called as a bailee? The person who is taking a portion of the goods. So take a reasonable care of the goods, not to make any unauthorized use of goods, not to mix goods with its own goods, duty to return goods, not doing any act consistent with the terms of bailment, and returning any profit. So returning any profit. So what do you mean by this? So whenever the person who is handovering the goods, whenever the owner is handovering the goods to the bailee, he has to take care with almost care. Because if, for example, I bought some valuable cloth for stitching purpose, I hand over this cloth to the tailor. Okay, so I have given clear instruction that since it is a very costly cloth, please take care of it. You should not do anything. Please take care of it. Or you should not do any, you should not mingle this product with your own goods or some other person's good, like that. I'm giving instruction. That is called to take a reasonable care of goods, not to make any unauthorized use of goods. That means if I'm handing the goods to the bailee in the sense, the ownership is of the goods is mine only, right? They should not earn any secret profit or they should not mix up with any kind of goods. As well as one the task has done at the time of promise, whatever instruction is given by the bailer, if it is fulfilled, then it is a duty of the bailee to return the goods to the particular owner. I'm not doing any act inconsistent with the term of bailment. Okay, then returning any profit. Then, for example, I have given a cloth. For example, I bought some unstitched cloth from the raiment shop. I have given to the tailor. I just informed him after 10 days I will come and collect it. Okay. So due to my personal situation, I could not go to the particular shop or collect a coat and shoe. But I informed to the tailor that okay, due to some emergency purpose, I am out of station now. I will come and collect it later on. But what this Bailey, the tailor, has done in the sense, without my knowledge, he left my stitched cloth, Raymond coat shoot cloth for rental purpose. Okay, this is not fair. This is void completely. Okay, so the particular Bailey should not involve in any kind of act which is against the bailment as well as the bailer. So rights and duties of the bailer and bailee. First one, to put bailee into the position. See, whenever to deliver the delivery to be bailee may be made during by doing anything which has the effect of putting the goods in the possession of the intended bailer, any person authorized to hold themselves in behalf. That means, what is that? I'm handovering the possession of the goods to the bailee, so he has to take care of it. Then to disclose the material fault. For example, when I'm handovering the goods to the particular bailee, in case if the particular goods is having some fault, or if there is any kind of some harmful effect or something is there in my product, I need to clearly communicate this information to the bailee. Okay, before starting his work, I need to communicate all the information about my product to the bailee. Why? Because if anything occurs because of my my hidden information, then it is the duty of the particular bailer to take care of the compensation. Okay, example, A lend a horse which he knows to be vicious to B. He doesn't disclose this fact and the horse is vicious. The horse run away. B is thrown and injured. A is responsible to B for the damage suspect. Okay, so to pay expenses of bailment. So as I told you that when I hand over the goods to the position of the goods to the bailee, in the sense, once he has completed his respective task, I need to pay for it. That is called to pay expenses of bailment. To indemnify the losses. The indemnity means promise to make a good to the loss. According to the section 959, Indian Act 1872, bailer has a duty to indemnify the loss suffered by the bailee under the Contract Act. So to pay the damage for non-disclosure act. So what is that? If a bailer does not make any disclosure to the bailee fault in the goods bailed, he is responsible for the damage arising the bailee directly from the fault. What do you mean by this? Example, A lend a horse, same thing. Again and again, I'm telling you, it is the duty of the bailer to communicate all the relevant information. He should not hide any information about the particular portion of the goods when he is handovering to the bailee. Why? Because if anything occurs, then he has to take care of the losses. For example, I'm having a car. I'm leaving my car for the from service purpose, for service purpose to the some workshop, automobile workshop. I know very well that from past 10 days, there is some problem, some major problem which is occurring in my car. There is a chance for major accident. Maybe some problem, automatic problem is there. Okay. So in this case, I need to communicate all the relevant information to my bailee before handovering the goods to him. If I hide those information, but after handovering the goods, if some accident occur, or if any kind of a injured occur to the particular bailee due to my goods or my product, then being the owner of the goods, I am responsible for that. To pay damages for defect in bailer's title, when I hand over the goods to the bailee, because of my poor performance or due to some defect in my product, if anything happens to the bailee, then it is a responsible of the bailer to take care of the compensation. Rights of bailer. So as of now, we have seen rights and duties of the bailer. That means duties of the bailer we have seen. Now we are going to see rights of bailer. As such, Indian Contract Act 1872 does not provide a right for the bailer, but sometime he is having certain right. Enforcement of bailie's duty. What do you mean enforcement of bailie's duty? At the time of entering the contract with the bailee, what are the instructions we are giving? We can insist a particular bailee to follow it. For example, I hand over the unstitched cloth to the tailor. I asked him, I have some festival in my, we have some festival or we have some function at my family. I need the goods to be stitched within the 3 days. I have given a clear instruction. Even he has agreed. But at the end of the third day, if I after I inquired the position of the goods and status of the goods, what I have given to him, if he is not saying no, 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 still is this in a stitching process, it yet to complete in the sense, then I can ask him. Okay, that is called enforcement of bailey's duty. Whenever we are handovering goods to the bailey, as a bailiff, we have a full right to ask the bailey to complete the task as per the instruction or as per the promise, whatever we have entered at the time of the contract. For example, if X deliver a suit lent to Y, his tailor, to stitch suit for him, a bailiff will see that tailor does not needful in the same manner. That's what I told you now. Then right to claim damages. In all case of bailment, the bailiff has the right to claim for damages against the loss if any cost to the goods bailed due to the bailiff's negligence or misconduct. For example, same, I have given some cloth to the tailor. Due to his carelessness, he mingled the cloth with somebody's cloth and then he missed mine, the owner of the goods. Okay. So in case if he misplaced my cloth somewhere, or he had wrongly delivered my cloth to somebody else, in the sense, what I can do, being a owner of the goods, I'm having a right to claim damages, right to terminate the contract. If the bailey does not comply with the terms of contract or act is negligent manner, in such case, the bailey has the right to resign the contract. What do you mean with it? For example, as I told you that I have given my unstitched clause to the bailey, then I have given a clear instruction that I have some family function. You have to stitch the clause and return back to me within 3 days. But after 3 days, when I went and inquired about my cloth, I came to know that he has not started it, the particular work. Okay, he has not started it to do stitching, or he has not done cutting of my cloth. Nothing has done so far. So what I can do, I can terminate the contract with the bailey. Right to claim compensation. So, for example, as I told you that I hand over the goods to the unauthorized person, that means to the bailey, for the purpose of adding a value or whatever it is. If he does something because of that, if any kind of a damage occurs to my product, then being a bailer, I have a full right to claim for compensation. A good example for this situation: A let B use his car, but with condition that shall drive, only B allows. So in this case, A is a no. He has given a key of a car to the B, and he has given a clear instruction that, see, I'm believing you because I know about you. So I'm giving this car key only for the utilization of yourself. That means you only has to drive. But without the knowledge of A, B hand over the car key to see one of his friend. He let him to drive. Due to some, some personal issue or whatever it is, that particular car met an accident. So now who is responsible? B is only responsible. Bailey only is responsible. Why? Because here A doesn't know the C. This is a bailment occurred between A and B. A is a bailer and B is a bailey. A hand over the goods to the B only, not to the C, as well as he has given a clear instruction. But just, by ignoring that instruction, B has hand over the goods to the C, in the sense, who is responsible for that? B only. Right to demand the return goods. That means once, whenever you enter in a contract with one person under the contract of payment, once they finish the goods, they have to return back. Okay, in case if they are not going to do so, it is a duty, it is a right of the principal to ask. Next, right to demand return of the goods along with the accretion to, if any. So what do you mean by that? For example, if you hand over some goods to some bailey, after some period, if anything additional advantages is added, in the sense, you can get it back along with the advantages, whatever it is there added. Example, A leaves his brooding hen in his custody of B to be taken care of for 1 week. The hen has hatched the chick. A is entitled not only to hen, but also to the chicks. Okay, do you understand? Next one. Duty to return the goods on the fulfillment of the purpose. So Bailey's duty to bound to return the goods once the purpose is achieved on the expiry of the period. So in case if the bailment is occurred between two parties based on some period, Once the period got over, the particular bailer having full rights to ask the goods back. Duty to deliver the bailer increase or profit, if any, on the goods bailed. That means a bailee has a duty to return the goods along with the increase or profit to subject to the contract of in bailment. See the example here. A leaves a cows in the custody of B and cows gives birth to the calf. Then B's duty bound to hand over the bailed goods along with the application to the particular accreditation to the bailer. So you can understand, right? So one person is a bailer. He left a cow for the custody of B for 1 month. Within this 1 month, the cow gives birth to the calf. So it is a duty of the bailee to hand over the cow along with the calf. Okay. Rights of bailee. So as of now, we have seen the duties and rights of bailer. Now we are going to see the rights of bailee. So right to recover the expenses. So now we have to think from the bailee point of view. That means tailor. Okay. So in day-to-day activities, we used to see tailor, right? He is the best example for bailee. So right to recover expenses. In the contract of bailment, the bailee incur expenses to ensure the safety of goods and the bailee. For example, once the bailee has completed his task, he can return the goods and get a expenses or reward whatever he had done for that. Right to recover compensation. That means that already I told you, being owner of the goods, the bailer should not hide any information which is related to the goods before handing to the products to the bailee. If he is going to hide any information, because of that, if any kind of an injury happened to the bailee, then the bailee is having full rights to get a recovery for the compensation occurred. Right to lien. So what do you mean right to lien? Right to lien in the sense, bailee has the right to overlien. That means that if the bailer failed to make a payment of the remuneration, does not pay the amount due, the bailee has a right to keep the goods bailed in his possession till the time debtor due are cleared. Do you understand? For example, I have given a clause to the tailor for stitching purpose. I have given around 10 saris. I have given an instruction to the bailee for stitching the sari as along with the blouse with the designs, everything. The cost was around, after she has completed all the work, the cost was around 4,000 rupees. So in this situation, I have given only 2,000. I had to give 2,000 in the sense here, the bailee is having full rights to retain the portion of the goods. That is called right to lien. So right to lien in the sense, when the bailee is not received the full amount which is promised by the bailer, he is having full rights to retain the goods. Next, right to suit against the wrongdoer. That means what is called wrongdoer. After the goods have been bailed, any third party deprive the bailee of the use such goods, then the bailer can bring an action against the third party. Termination of bailment. So, and what are the way the bailment will comes to end? The contract of bailment can be terminated by any of the following: accomplishment of the purpose, expiry of time, death of the parties, and bailey's inconsistent act. So what do you mean by this, students? They already in the last class we have seen the termination of agency, termination of a contract. See, by whatever may be the act, there are certain basic topic will be like essential elements, then formation, then types, as well as rules to be followed. At last, termination. Okay, so being a student, we should always learn all the aspects in each and every contract, in each and every act. Okay, so now in this topic we have seen what is called bailment, who is a bailer, who is a bailee, as well as what are the types of bailment is there, what are the duties and rights of the bailer, what are the duties and rights of the bailee. So the last topic is termination of the bailment. So what is called termination? In what are the way the bailment will comes to end. Okay, so this is the end of the particular bailment. So accomplishment of the purpose. For what purpose you hand over the goods to the bailee? If the purpose is completed, if the purpose is fulfilled, automatically the bailment will comes to end. Next, expiry of time. So what is called expiry of time? If the bailment is created for the based on some period, if the time exceeds, automatically the bailment will comes to end. Death of the parties. In case if any one party, either bailer or bailee, dies unexpectedly, then automatically the termination of bailment will occur. Then bailee is inconsistent act. A contract of bailment is voidable at the opinion of bailee does any act with regard to the goods bailed with the condition of the bailment. So these are all the way the bailment will comes to end. So this is the one case study is given here, the real case study. Vishalakshmi versus Kalya Perumal. So this is a case study is about Vishalakshmi and Kalya Perumal. So what is that instance? The Vishalakshmi is a customer and the Kalya Perumal is a goldsmith. Vishalakshmi, the customer, she hand over the raw gold to the goldsmith Kalya Perumal, and she requested the goldsmith to make us an ornament. She used to carry the raw gold, and she used to sit along with the goldsmith, and she will be seeing all the entire process of making the ornament. Okay, in presence of her only, the goldsmith was doing all the alteration, all the making of the ornament. After 3 to 4 days, what happened? She was she was fighting with the goldsmith, that she was giving some statement that I have given a raw gold worth of this much gram, maybe 50 gram. But after you completed this ornament, this is very less weight. So you only did something. That means you did some, malpractice, or you have done some, some alteration in the gold or something. Then what happened? She filed a case. She sued against the Kalya Perumal, the goldsmith. Then this case was handled in the court. Then at last, the judgment is favored to the goldsmith. Why? In the sense, all the ornament making process is done in front of Vishalakshmi only. So every day she used to carry the gold, and she will be sitting along with the goldsmith, and she was doing all the things. So, okay. So there was no, any chance for the goldsmith to do any kind of a malpractice, something else. At last, the case is favored to the Kalya Perumal. So this is a best case study example, which is related to the bailment. The next one is contract of pledge. So as of now, we have seen a contract of bailment. Now we are moving on to contract of pledge. So what is called pledge? Pledge means sort of mortgage. A pledge is only a special kind of a bailment, and chief basis of destination is on the object of the contract. So the bailment of a goods or security for the payment of a debt or performance of the promise is called the pledge. See, there is a difference between bailment and pledge. So under the bailment, the bailer will be handovering the goods for the purpose of adding up the value to the goods and redeliver it to the particular bailer. One case. In another case, he will be handovering the goods to the bailee for the purpose of utilization. For that purpose, he may either collect money, or sometimes he will not collect money. That is called bailment. Whereas under the pledge, due to some personal, requirement, due to some financial problem, or due to some immediate emergency purpose or whatever it is, if one person, mortgage his property, the property might be gold or some, valuable things or land document or whatever it is, that is called as pledge. The person who is keeping, mortgage or, keeping his goods for mortgage purpose is called as a pawnee. To whom he is giving this product is called as pawnee. The best example I can give you, every place we used to see some small gold shops will be there, mortgage shop will be there. So our housewomen, whenever they have certain financial problems, they used to carry the small jewelries and some jewelries. What they will do, they will give and that set. We used to say set. Okay, we will go and meet that set shopkeeper. We will be handovering the goods. For that, he will be charging some interest also. we will be giving a promise within 6 months. I will give you the interest along with the principal. I will be taking the goods back. So this is called pawnee concept. The said who is taking your product for the custody and giving you money, that bailey is called as a pawnee. Okay. Whereas the person, the ownership of the goods, the owner of the goods is called as a pawner. Okay. The simple difference is under the pawnee, the pawnee will be collecting an interest for the amount what is given to the product. Okay. Whereas under the bailey, under the contract of bailment, the bailey will not charge any interest. The whatever work he has done, for that he will collect a money from the bailiff. This is a basic example. Joseph is in urgent need of money, so he has deposited his gold and watch to Michael as a security for the money lent. This is a case of pledge whereby gold watch is bailed as a security for the amount lent. Here, Joseph is the pawner and Michael is the pawnee. Features of contract of pledge: delivery of possession. So one of the most basic but important characteristic of pledge is that there should be a delivery of a portion of the goods from one party to another. The property pledge should be delivered by the pawner to the pawnee. So as I told you that here portion of the goods is transferred. In this contract of pledge also ownership is not transferred, only the portion of the goods is transferred. In pursuance of contract, it is important feature of the pledge is that delivery of the goods by the pawner to the pawnee shall be done in pursuance to the contract of pledge. But it is important to note that the contract for pledge and delivery of goods need to be contemporaneous, in sense that it is necessary contract of pledge delivery has to be done in the same time. What do you mean with this? Same way, how in bailment, the bailment is occurred based on some time period. Same way here also, the pledge also, on the pledge contract also done based on some period. Okay, who can pledge? Anyone can pledge their property, or any representative or nominee of the owner can pledge the particular product for money purpose. Rights of pawner and pawnee. Right to receive back the goods. So pawner after the due payment of the goods. For example, I have, due to my financial problem, I pledged my home document. Okay, then I have taken some money, some volume of money from the particular pawnee. So after some period, actually this contract, the contract pledge entered for 2 years. 2 years in terms of 10% of interest. Before 2 years, I have paid the payment, in the sense I have a full rights. The pawner is having full rights to receive back the goods. That is called right to receive back the goods. Next, pawner's right to redeem. So what is called pawner right to redeem? Pawner rights to redeem is stated in section 177 of the Act. Section 177 states that if a time is stipulated for the payment of the debt, performance of the promise for which the pledge is made, and the pawner makes default in payment of the debt, the performance of the promise at the stipulation period, he may redeem the goods pledged at any subsequent time before the actual sale of them. But he must, in this case, pay in addition any expenses which have arisen for his default. So do you understand? So as I told you, the pledge also occurred based on some time period. Before the time period expire, the particular pawner, sometimes he can settle down all the amount. He can redeem the product, whatever he has, hand over to the pawnee. Right to suit. So what is called right to suit? This is a right indirectly discuss about the pawnee's right to sell, but after giving the proper notice to the pawnee. The right entitled the pawner cannot sell the goods as when he want. See, for example, I have given a goods to the said, that gold shop person. I kept my jewelry for 1 month for motive purpose, pledge purpose. So I could not able to recover my gold due to some financial problem. Then what he will do? He will be keep on giving a notice that you have pledged your jewelry for this much amount. The particular contract is entered based on the 10% interest or whatever it is. As of now, you have not paid interest also. So your due date is going to complete. If you are not going to pay the amount, your product will be resell to somebody else. Like that, he will be giving some instruction. So unless otherwise he give a proper instruction, or before the date of expiry time, If the pawnee sell my goods to somebody else, then being the owner of the goods, I have a right to suit against the particular pawnee. Okay, next, care and maintenance. The pawnee has the duty to take care of the proper care and maintenance of the security so that the security does not depreciate its values. That would be, that means what you mean by that? Whenever we are handovering goods to the pawnee, that means the shopkeeper, he has to take care of the goods in his custody in a proper way. He should not say anyone that later on, no, the goods has misplaced somewhere, somebody theft the jewelry, or something is is misplaced somewhere, or is mixed with some other's jewelry, so that we lost the jewelry. He should not say anything. It is a duty of the pawnee to take care of the goods in a proper way, and then in a proper state how the pawnee has handled the goods. The rights and duties of the pawnee. Right to receive a payment of the debt or obtain the performance of the profit with the interest and expenses. So pawnee has the right to retain the portion of the goods and pledge till he obtain the payment of his debt interest. So as a pawnee, the shopkeeper of the jewelry shop owner, he's the said person, he is having full rights to withhold the portion of the goods until he receive a money and along with the interest from the pawner. Okay, so he is having full rights. So until otherwise the pawner clear all the dues along with the principal amount and interest, the pawnee is having full rights to withhold the portion of the goods. Rights of lien. So pawnee has no right to retain the portion of the goods once the pawner has paid the full amount. Do you understand? For example, students, for example, I have pledged my jewelry for 1 year. Before the 1 year, at the end of the 9th month itself, I have given a full amount along with the interest in the same. No more the pawnee is having rights to retain my goods. Why? Because before the expiry of the fixed period of the contract, I hand over my full amount. I have cleared my all due along with the interest in the sense. In this case, the pawnee, he has to hand over all the goods. He should not retain any kind of goods. He has to hand over the goods to the pawner. Right to receive extraordinary expenses. Pawnee is also entitled to receive from the pawner any extraordinary expenses which might have occurred for the preservation of the gold pledge. What do you mean by this? For example, in case if the pawnee is in a position to take care of a goods, if the pawnee is in a position to give some extra care, or if he wants to give some additional safety to the product. For that purpose, if he has done any act for the purpose of safeguarding the pawner's product, then the pawnee is having full rights to receive extraordinary expenses, whatever he spent for the benefit of the pawner product. Pawner's right in case of default of pawner. In case of a default of the pawner in the payment of a debt, performance of the promise at the stipulated time on demand within a reasonable time, the pawnee can exercise the following two rights. So what do you mean by this? When the owner of the goods, the person who pledged the jewelry, if he is not going to pay the amount on a particular period, what is mentioned in the contract, then the pawnee is having full rights to resell the goods to somebody else after giving a proper notice, or else he can file a case against the particular pawner. He has a right to claim any deficit arises from the sale of the goods pledged from the pawner. He will have to return the pawner's excess obtained by the sale of goods pledged beyond the amount necessary to pay the debt other than the expense due. Pawnee must not use the goods pledged. So I, as a pawner, owner of the jewelry, I have pledged my jewelry to the some jewelry shop owner. Okay, said then he has to safeguard my jewelry till the particular contract get over. Because for that purpose only he is charging interest. Before the time get exceed, he should not use my property. That means the pawner property for his personal use. Okay, so because for what purpose I'm pledging my jewelry for money need. Okay, so it is rights of the pawnee should not use the goods whatever is pledged by the pawner. Duties of the pawner. So who is a pawner? Owner of the goods. Pay the debt. The owner is liable to pay the debt, perform his promise to the paid. That means whatever, for what purpose you enter in a contract, I mean under the pledge, for getting some money. So you have to pay a money whatever you have agreed with the particular pawnee. Pay deficit on sales. If the pawnee sells the goods due to the default by the pawnee, then he may pay the deficit. So what do you mean by the pay deficit in the sense? For example, the value of the goods, I pledged my jewelry, which is around 10 severance. 10 severance means what? 800 gram. Okay. Right. 800 grams. Sorry, 80 grams. I have pledged my jewelry, 80 grams jewelry. So 10 severance. So I pledged the 80 grams jewelry, but I received only maybe 1 lakh or 2. I received only 2 lakh only from the particular shopkeeper. Okay, but the actual cost of the original cost of the product is around maybe the 10 lakhs. But I received only 2 lakhs. I pledged my jewelry. I received only 2 lakh. So in this case, I entered a contract with a particular pledge under the contract of pledge. Only we entered a contract for 1 year. Within a 1 year, I promised him I will pay the amount along with the interest and I will take my product back. But within this 1 year, I could not able to pay the amount along with the interest in the sense. After giving all the proper notice by the pawnee also, being a partner, I could not be able to pay money. In this situation, what actions the pawnee will take? He will sell the goods to somebody else. Even though I have pledged my jewelry, which is around 10 lakh rupees, I received only 2 lakh for pledge. But the cost of the product is 10 lakh. So what will happen? So once the pawnee sells the goods to somebody else for 10 lakh rupees, he will withdraw the only 2 lakh, whatever he has taken. Then he will charge some interest, right? So he withhold 2 lakh along with the interest. Then he will be returning back the remaining amount to the particular owner of the goods. That is called pay deficit on sale. So what is called pay deficit on sales? If the particular value of the goods is higher than the value what you have pledged, then at the time of selling the goods, it is a it is a duty of the partner to get the remaining amount of the particular product what you pledged from the pawnee. Pay extraordinary expenses. The pawnee is liable to pay to the pawnee in any extraordinary expenses incurred by the pawnee for the preservation of good. Preservation means for safeguarding the goods, as I told you, right? In case if the pawnee is taking any extra care to safeguard my goods, in the sense I can give a extra amount for that. Disclose fault in goods. As I told you, under the time of bailment also, whenever we hand over a portion of the goods to somebody else for the purpose of anything, it might be the pledge, it might be the bailment or whatever it is. If the particular goods carries some default, we should communicate this information to the particular person to whom we are handling the goods. That is very much important. And this are material for use of the goods and may put them funny and extraordinary risk. Because in case being a owner of the goods, either bailer or pawner, if you are not going to disclose the information, because of that, if any kind of a loss occur or if any kind of injury occur to the bailee, then who is responsible? Who is pawnee? Who is responsible? Bailer and pawner only. Indemnify the pawnee. That's what I told you. If you are not going to disclose all the information, because of that, if any kind of a accident or something occurred to the pawnee or bailee, then the pawner and bailer is only responsible for that. Duties of the pawnee. Pawnee is a person who is receiving a product and having the possession of the goods and handovering some money to the particular owner of the goods. That is called, he is called as a pawnee. So he should not use the goods on his own name. He should not use it for his personal purpose. As well as once he receive a money along with the interest from the pawner, he must return the goods immediately to the owner of the goods. He should not carry any rights towards the goods. Take a reasonable care. when the goods is hand over to the pawnee, he has to take care of utmost care about the product, and he should not mix up that particular product along with his own product, and as well as he should return increase in goods. That means the pawnee must return the pawnee any pawner any accretion to the goods pledged with. We already have seen, right? In case if you are pledging some goods, for example, I am pledging my my cow. In village side and all, it will occur. Okay, sometime I'm pledging my cow for 1 week. I received 5,000 rupees. During the time of this 1 week, my cow has given a birth to calf in the sense, though I paid the 5,000 in the sense, the particular person, he has to return back my cow along with the calf. That is called return increase in the goods. This difference between pledge and bailment. Pledge is a bailment of a goods for specific purpose, whereas a bailment for the purpose is any kind, maybe whatever it is. So, and already we have seen under the bailment is occurred based on two purposes, either for the purpose of collecting money or for the purpose of utilization by somebody else. Okay. Whereas under the pledge, the main purpose is to gain a money. We are pledging our property to somebody else for some period. For that, interest will be charged. So, what are all the way? This will already we have seen. Pledge or pawn. So here, similarly, the similarity of pledge and bailment. Wailer is called as a pawner and bailee is called as a pawnee. So under the bailment and pledge, the difference are the purpose of the bailment is either for security or repair purpose. Right of sale is not available under the bailment, whereas under the pledge is available. So we have seen all the things. That's all. Now, contract of bailment over, contract of pledge over, another two act we had to discuss. The contract of indemnity. So what is called contract of indemnity? The indemnity, the definition, section 124, a contract by which one person promised to save other from loss caused to him by the conduct of the promiser himself, by the conduct of any other person, is called as a contract of indemnity. Is contract of indemnity in the sense when one person is giving assurance to safeguard other person, that is called as a contract of indemnity. Okay, so in this also there are two parties are available, indemnity holder and indemnity buyer. So who is called indemnity holder and indemnity buyer? Let's see in the class. So example is car insurance policy. So what they will do, usually the insurance companies are, there are a lot of insurance companies there. The main purpose of insurance companies are what? To safeguard somebody else, to safeguard somebody else. For that purpose, they are charging the money. So that is called as an indemnity. When one person is giving assurance to other person to safeguard, for that purpose, if they are collecting some money, reward, that is called as an indemnity. Contract of indemnity. A contract of indemnity is a contract whereby one party promised to save another from the loss caused to him by the conduct of the promise itself. For example, I'm driving a car. Okay, I have a car. I have taken insurance for my car. Due to some poor driving, I met an accident. So here the loss occurred. Okay, by myself, the owner of the car itself. For that also, sometime I can, if the reason is valid, I can claim a compensation. Or if somebody hit my vehicle, because of that, if damage occurred to my vehicle, then I can claim for it. So we have to very clear under the contract of indemnity, whereby the loss occurred in a two way, either by the promisor itself or the third party. Okay. Essentials of contract of indemnity: parties to a contract, protection of loss, express or implied, covers only the actual loss, essentials of valid contract, number of contract, depend on good faith. Parties to a contract: there must be two parties, namely promisor and indemnifier, and the promisee and indemnified and indemnity holder. So who is called promisor, indemnifier? Okay, then who is called promisee, indemnified and indemnity holder? Protection of loss. A contract of indemnity is entered into for the purpose of protecting the promise from the loss. The loss may be caused due to the conduct of the promisor. Okay, so again, I'm telling you, when one person giving assurance to another person to safeguard, that is called as an indemnity. This kind of an indemnity might be express or implied. Express in the sense it might be either in oral or written, whereas implied in the sense sometimes due to the conduct of the parties' relationship it may occur. It's cover only the actual loss, not other than that. Features of indemnity, it must possess all the ingredients of valid agreement in contingent agreement to make a goods and loss. The loss must caused by the human contact only. Loss must have an actual it suffered. The parties to a contract of indemnity, indemnifier and indemnity holder. So example, motor insurance, marine insurance and fire insurance. Indemnity, the rights of indemnity holders are to claim a damages, to claim cost, the other payment. So who is called as indemnity holder? The person who is taking a insurance. Okay, the person who is taking the insurance. So he can claim a cost, he can ask any claimant, or he can ask any kind of a damages. A person who promised to make a goods loss, make a goods losses, the promise is called as an indemnifier. The person who lost it to be made good, the promise is called an indemnity holder. The person who is indemnified is called as a indemnified. By a contract of indemnity, a security is provided to the promisee against any anticipated loss. Indemnify means to save from loss. So, essential rights of indemnity must contain all the essentials of valid contract. Promisee must have a suffered loss. Rights of indemnity holder. Promiser, the person who's safeguarding, the person, insurance company is called as a indemnifier. The customer is called as a indemnity holder. So keep it remember, the person who is giving assurance or who is giving promise to safeguard somebody else, the promiser is called as indemnifier. The person who is saved, who for promisee is called as an indemnity holder. Entitled to recover a promiser, entitled to recover from the promiser cost, and entitled to recover from promiser all sum. So that is called contract of indemnity. The last one under the special contract is contract of guarantee. So what is called guarantee? The purpose and meaning of the contract of guarantee is a contract to perform the promisee and discharge the liability of a third person in case of this default. So guys, students, under the contract of guarantee, there are three parties will be involved. We'll see in this. So what is called contract of guarantee in the sense when one person is collecting some money or involving the contract with another person, for that purpose, he needs somebody's security or somebody's assurance or somebody's nomination or somebody's help for the making of that contract. That is called as contract of guarantee. Parties to the contract, there are three parties involved in the parties to the contract. Surety. Surety is the person, the third party who is giving some guarantee to the debtor. That is called as a guarantee. For example, Mr. Suresh, he needs money. He needs around 10 lakhs. So he is approaching me. So here I'm the person, money lender. I'm a creditor in this example, and Suresh is a debtor. Just like that, I will not, even though he might be know very well to me, I will just like that, I will not lend the money to him. I need somebody's security, guarantee, surety. I need surety, right? So in this, one of the person who knows very well Suresh, he is entering in the contract and he is giving assurance that Suresh, he will be returning back the money within this time period along with the interest. If he is not going to return back the money, I'm a guarantee, I'm a assurance person. I will be taking liable for this. I will be taking the responsible for that. Okay, so this the third party who is entering in this contract is called as a guarantee or surety. The person who is getting a money is called as a debtor. The person who is giving money, okay, the person who is giving money, the owner of the money lender. I am giving 10 lakhs to Suresh in the sense, in this example, I am the creditor. Okay, the person who is receiving money, Suresh is receiving money from me, right? So Suresh is a debtor here. And another person, maybe Vicky entering in a contract to give a surety to the Suresh in the sense, here Vicky is a surety person. So this is some small example. Here also I have given an example here. X advanced a loan of 25,000 to Y, and Mr. Z promised in that case, Mr. Y failed to repay the loan in the sense he will repay the same. In this case of contract guarantee, X is a creditor and Y is a principal debtor and Z is a surety. Essentials of a contract of guarantee. It must be made with the agreement of all the parties. Consideration, liability, presuppose the existence of debt, must contain all the essentials of valid contract, no concealment of fact, no misrepresentation, and writing not necessary. Must be made with the agreement of all the three parties. All the three parties to the contract, that's a principal, debtor, creditor, and the surety must agree to make a such contract. So purely the contract of guarantee is entered based on some agreement only. Okay, it is not in a oral way. Always the contract of guarantee is entered based on some documentation. Okay. Example, Sam lends money to Akash. Sam is a creditor and Akash is a principal debtor. So Sam approached Raghav to act as a surety without any information to Akash. So Akash agrees. This is not a valid. Okay, when one person is acting as a surety in the sense, the particular person should be agreed from both the parties. The creditor and debtor, they must know very well that the so-and-so person only is going to act as a surety. Do you understand? So we should be very clear, these three parties' presence is needed at the time of putting signature in the agreement. So what is called consideration? Consideration means something in written, right? So whenever two parties enter in a contract, something will be written, something either it might be money or product or whatever it is. Okay. So in State Bank of India versus Premco Sawmill 1983, the State Bank gave a notice to the debtor defendant and also threatened a legal action against her. But her husband agreed to become a surety and undertook to pay the liability and also executed a promissory note in favor of the State Bank, and the bank refrained from threatened action. It was held that such patience and acceptance of the bank's part constituted goods consideration for surety. So what do you mean with this? Already I told you that at the time of entering the contract itself, one person, if any one person, the third party, the surety is going to enter in the sense, it must be known to both the parties. Later on, they should not be involved in the contract. Liability. In contract of guarantee, liability of a surety is secondary. Okay, see, for example, I told you that I'm giving 10 lakhs to Suresh. Vicky is giving surety to the Suresh in the sense here, I will not disturb Vicky. Being a creditor, I will not disturb Vicky until otherwise Suresh is not going to pay money. Okay, if Suresh is fulfilling my all the condition, if Suresh repay my money along with the interest in the sense, I will not disturb Vicky in this case because this full liabilities lies on only on the debtor, the person who is receiving the money, not a surety. Surety is sort of some assurance is given to the particular debtor for getting some amount from the creditor. That's it. Presuppose the existence of a debt. The main function of a contract of guarantee is to secure payment of the debt taken by the principal debtor. If no such debt exists, then there is nothing left surety to secure. See, once Suresh has paid full amount before the fixed period, for example, myself, Suresh, and Vicky, we entered in a contract for 1 year. Okay, he took around 2 lakhs from me. Before the 1 year, the time period ends, he settled down all the amount in the sense the contract will come to end. Okay, here no way that the surety will be involved further. So here some case study also is given. The House of Lord in the Scottish case of Swan versus the Bank of Scotland in 1836 held that if there is a no principal debt, no valid guarantee can exist. Must contain all the essential of valid contract. So this kind of a surety guarantee, all kind of this contract of guarantee must fulfill the condition of the contract 1872. Under the Contract Act 1872, we have studied certain essential elements of valid contract. So whatever may be the contract, it might be the contract of pledge, contract of bailment, contract of indemnity, especially under the contract of guarantee, we should follow all the rules and regulations. We should follow all the rules and regulations which is prescribed in the under the contract of 1872. Okay. No misrepresentation. The guarantee should not be obtained by the misrepresenting the fact to the surety. That means the third party, when he is entering and giving assurance in the sense, whatever information is being transferred related to the particular contract must be clearly communicated to the surety also. The principal debtor and creditor should not hide any information to the surety. So he has to make sure, the surety also he has to make sure that there is no any kind of a hidden information in this contract. Why? Because if the debtor is failed to pay money, if the debtor is failed to fulfill the promise what is given to the creditor, then who is responsible? Ultimately the surety, right? So the surety must know, the guarantee person, the surety must know very well about all the aspects of the contract. That is very much important. Writing not necessary. A contract of guarantee may either oral or written. It may express implied for content of the parties. These are all the kinds of guarantee. Unilateral contract of commercial credit, bank guarantee, letter of credit, absolute performance bond, retrospective guarantee, prospective guarantee, specific guarantee, and continuing guarantee. What is called unilateral contract of commercial credit? This is a type of a contract of guarantee usually seen in a trade transaction. It commonly arises between the wholesaler and the retailer. It arises between, usually the contract between the wholesaler and retailer occurred based on some credit basis, right? Every time they will not settle down the money. So maybe 10 days once, or 20 days or 1 month or 6 months once, they will be settling down their transaction amount and all, because their relationship is a continuous relationship. In such case also, they need somebody's surety, because there is a lot of chance for misleading or fraudulent activity, right? So for that purpose, if you are bringing some third party, that is called unilateral contract of commercial credit. So what is called commercial credit is if you are bringing any kind of a surety for the purpose of any kind of a commercial transaction or commercial business, that is called unilateral contract of commercial credit. Then what is called bank guarantee? Bank guarantee in the sense when you are availing loan or money from the bank for that purpose, if they need any surety, that is called as a bank guarantee. What is called continuing guarantee? A continuing guarantee is defined under the section 129 of the Indian Contract Act 1872. A continuing guarantee is a type of a guarantee which applies to a series of transactions. It applies to all the transactions entered into by the principal until it is revoked by the surety. Therefore, the banker always preferred to have a continuing guarantee so that the guarantee liability is not limited to the original advance. For example, see here, on M's recommendations, yes, a wealthy landlord employs P as his estate manager. It was a duty of a P to collect rent every month from the tenant of S and remit the same to the S before the 15th of every month. M guaranteed this agreement and promised to make a good any default by P. This is a contract of continuing guarantee. So what do you mean by this? When one person is giving assurance to the another person for continuing certain services, that is called as a continuing guarantee. The most important features of this continuing guarantee is that it applies to the series of separable distinct transactions. Letter of credit. So what is called letter of credit, which is occurring in our day-to-day activities due to some emergency purpose when we are not in a position to approach a bank for loan purpose. Because if you are going to approach a loan, in case if you are going to approach a bank for loan purpose, we have to follow certain protocols which is framed by the banks. We have to follow all the rules and regulations. Due to some emergency situation, sometimes we'll be approaching our nearby person, either some known person, some neighbors, or somebody else. So that time, what they will do in one paper, they will be writing all the information, so how much amount you are collecting, or the person who is a principal debtor, who is a creditor, who is another person giving a surety for that. So that is called as a letter of credit. So letter of credit is an instrument which is written by one person to other about giving a credit. Okay, so this is also a legal one, uh, but due to some emergency purpose only, sometimes it is being used in a day-to-day activity. Absolute performance bond. Absolute means perfect. It also means complete. In this type of a guarantee contract, the surety pays the amount written in the contract upon the failure to discharge contract by the person against whom the guarantee is given. Sometime, if the particular debtor is failed to pay a money, the surety he has to give a money. So that is called absolute performance bond. Okay, retrospective guarantee. What is called retrospective guarantee? When the guarantee is given for existing obligation or debt, is called as a retrospective. That means, what to say? I have given 2,000 to Suresh. At the time when I enter in a contract, there was no presence of a surety. Vicky has not entered in this contract. Okay. So, but after some period, after 6 months, I just came to know that, oh, Suresh is, I don't think so, he's not going to give a money. So I need to do something. For that purpose, what I'm doing, I'm asking Suresh, please bring some surety for this purpose. Because I don't think so, you are not going to pay a money. I need somebody's assurance. Do you understand? At the time when you are entering the contract, at the time when you are giving some money or lending something to a, under the contract of guarantee, there is no surety presence. But after some period, you are entering, you are requesting the principal debtor to enter one surety into the contract. That is called retrospective guarantee. Prospective guarantee, when the guarantee is given for future obligation, our debit is called for prospective guarantee. Okay, next, specific guarantee, when a guarantee is given in respect of a single debt or specific transaction. So in this, for one particular transaction itself, for example, I need to transfer my goods. I need to transfer my goods for from here to Bombay. Okay, so I'm handovering goods to Mr. Murugan in the sense, this is a valuable goods. Okay, so just like that, I can't able to hand over the goods to Mr. Murugan, even though he might be a businessman or he might be doing some logistic business or whatever it is. So in this case, I'm expecting Murugan to bring some surety for this contract. That is called specific contract. For specific transaction, if you are asking anybody, the other party to bring a surety, that is called as a specific guarantee. A is a bookseller who supplies a set of a book to P under the contract, that is, if P does not pay for the book, his friend K would make the payment. This is a contract of specific guarantee, and the K and liability to come to end the moment the price of the goods book is paid to S. That's all. So the contract of guarantee, already we have seen the meaning of this. So what are the rights surety against the creditor? So in case rights, in case of fidelity guarantee, in case the guarantee, it's a good behavior honesty of the principal debtor, the surety can ask the employer to dispense with the services of the employee if the letter proved to be dishonest. So what do you mean with this? Well, for example, in this case, I have paid, I have given us 2 lakh rupees Suresh, 2 lakhs rupees to Suresh in the sense, Suresh has paid the money along with the interest in the sense. Here, the guarantee, the surety person can enforce the creditor to relieve Suresh from all the obligation. That is called right in case of fidelity guarantee. Before the payment of the debt guarantee, a surety may, after the debt has become due, but before he called upon to pay, the creditor sue the principal debtor to recover the debt. So that's what I told you. Before the date of the particular contract also, sometime the debtor can settle down all the amount to the creditor and he can come out from the particular contract. Right to claim securities. So in case if the particular creditor is taken some security from the debtor for the amount what he has given in the sense, once the particular debtor has paid full amount along with the interest in the sense, the surety can force or enforce the particular creditor to give all the securities whatever is given by the debtor. Do you understand? For example, Suresh, he has taken a 2 lakh rupees from me. Then he has also given his car for 1 month because he needs some money for emergency purpose. He said within 1 month I will return back the money. He said, I asked, bring one surety. He said, okay, I can't able to bring a surety, but I can give you some surety of a product, like I will give you my car. In the sense, once Suresh gives amount, whatever he promised, along with the interest, then I can return back all the securities, whatever is given by the debtor. Rights of equities. So after paying the amount due to the particular creditor, the surety is entitled all the equities credited that he had against the debtor, any person with regard to the debt. That means it is a duty of the surety to make sure that once the debtor has cleared all the due along with the interest or whatever it is, he has to relieve him completely from all the contract, whatever is existed between the creditor and debtor. Right of set off. So what is called right of set off? Sometimes the principal debtor is entitled to certain counterclaim or deduction from the loan obtained from the creditor. In such case, the surety is entitled to the benefit of such counterclaim deduction if the creditor files suits against the surety. Sometime, in case he has taken some only 2 lakh rupees, but due to some emergency purpose, he wants to settle down. For that purpose, he is handovering some other goods, which is more than the value of 2 lakh in the sense. The remaining amount, maybe for example, I'm telling you, Suresh, he has taken the same 2 lakh rupees. For that purpose, he has not given any kind of a security of any kind of a goods or product or anything else, but he brought one surety person. Okay. So he entered in a contract for 1 year. Within the 1 year, he could not able to pay 2 lakhs rupees. So here the particular principal creditor, myself, I'm asking the Suresh, where is your amount you didn't pay along with the interest? Then Suresh is calling, and I also will be approaching the surety. You are the person, Vicky. The Vicky is a surety. So you are the person was giving assurance to the Suresh that in case if he's not going to pay money, you will give back. So now give me the answer. So in this case, what Vicky Suresh is telling, I'm sorry, I don't have money to repay you. Instead of that, I will give you my car. This car cost is around 5 lakh. Please accept it. If he's saying like this, the surety can talk in between myself, the creditor and debtor in this case. Okay, then I accept it. There is no way, because I know very well that I can't able to get a money from Suresh. In this case, what I did, okay, I accepted the particular car as some property or whatever is handed out by the particular debtor. But the cost of the product is higher than the amount what is taken by the principal debtor. So what I supposed to do, the remaining cost, maybe if the cost of the car is 5 lakhs in the sense, he has taken a 2 lakhs, the interest is around 20,000 only in the sense, remaining amount 2,80,000 I need to hand over to the particular debtor in presence of a surety. That is called right of set off. Do you understand what is called right of set off? Next one. Right of surety against the principal, right of subrogation after payment of the debt to the principal, the surety is subrogated to the rights of the creditor. He has the same right to those of the creditor, therefore he can sue the principal debtor exercise those rights. So when he settled down all the amount, he has completely relieved from all the surety, whatever it is there. Right of indemnity. So already we have seen in every contract of guarantee that implied promise by the principal. If anything happens, that means if the principal debtor is not going to pay money, it is a right of the creditor to ask the surety to give assurance for the particular money, whatever is not paid by the debtor. Right to be relieved from the earlier, as I told you, before the payment date also, sometimes he can pay a money, he can come out from the all the debts and all the contracts. So discharge of contract, it's occur based on the notice of revocation, death of surety, variation of contract, release or discharge of principal debtor, and loss of security, creditor act, and commission impairing to the surety eventual remedy, and by composition with the principal debtor. So what do you mean by discharge? What are the way? Already we have seen termination of a bailment, termination of a pledge. Same way, discharge of guarantee. So what is called discharge of guarantee? In what are the way the guarantee will comes to end? So sometime by giving a revocation means cancellation. By giving a proper notice, the particular contract of guarantee will comes to end. Or if any person, the principal debtor dies, or creditor dies, or surety dies, if anything happens, okay. So, but sometime if the debtor, he collected a money and if he dies in the sense, the person who's related to the debtor, maybe the relatives or nominee or whoever it may be, they are responsible to pay a money to the creditor in case if there is no surety. Whereas if the surety is there, in the sense it is a duty of the surety to compensate to the principal creditor. Okay. In case if the surety itself died, then the contract will comes to end. Variation of the contract. If the subject matter of the contract is getting interchange or alter, automatically the contract will come to end. Then loss of security, creditor act upon the surety and composing with the principal debtor. So difference between the indemnity guarantee and basic difference, as I told you, that indemnity is where one party is promising other party to safeguard him. That is called contract of guarantee. Whereas surety, in the sense when one party is giving assurance to the another party for the purpose of taking some money. So under the indemnity, two parties is there. Under the guarantee, three parties are there. Under the indemnity, indemnifier and indemnity holder. Whereas under the guarantee, three parties: surety, principal debtor, principal guarantee. Okay. So these are the things. So that's all. So thank you. So I hope so you understand this class. So kindly view the description box. I have mentioned all the informations, whatever related to this particular special contract. So if you take any kind of contract, the special contract is very much important. If you want to start up any kind of a business, you should know this very well. Okay. So in day-to-day activities, every day we are entering a contract with somebody else, but we do not know the terms of it. So students, please view the description box, and the previous class link also mentioned in this description box. Okay. So kindly view it and subscribe it. Thank you.